Welcome to our coverage of the Noor Salman trial here on clickorlando.com. I'm Julie Broughton. Within the past hour, we have learned the defense is moving toward filing a motion to get bail for Noor Salman. This comes just hours after a judge denied motions for acquittal. Let's get to News 6 investigator Mike DeForest. He has been at the courthouse all day. And Mike, we also just learned from Salman's attorneys they will begin presenting their case Monday, calling 13 people to the stand.
They expect the defense's side of the presentation to last about 2.5 days. After that, there will be closing arguments. So it's very possible that the jury could begin deliberating this as early as late next week. Now, today the jury was off. They've been off every Friday, but the attorneys were here at the federal courthouse. They had to address two big issues. One, this motion for judgment of acquittal, which we'll get into in just a moment here, as well as hammering out jury instructions. The jury, before they go into the deliberation room, is going to be read some instructions. Today, the attorneys basically fought over word for word what those instructions will say. Joining me right now, attorney Whitney Bone. Today, the attorneys began the morning talking about this motion for judgment of acquittal. Take me back to law school, even though I've never been to law school. What is that?
Okay, a motion for a judgment of acquittal is where the defense or the defendant in a criminal trial asks the judge to not let the case go to the jury, basically to find that the defendant is not guilty, enter a judgment of acquittal, because they're arguing that the government hasn't proven a prima facie case of the crime, which is a fancy legal way of saying that the government, in a light most favorable to them, meaning all factual disputes or credibility or weight of the evidence issues aside, has failed to put on a case of the essential elements of the crime. And so it could be that the defense argues, they're missing one element of the crime, that there just wasn't adequate evidence of that for you to give it to the jury judge, or it could be all of the elements. In this case, they basically argued they didn't prove what they were supposed to prove, and as you know, the judge ended up denying it.
Judge says the trial will continue, and I think that's generally expected in these. Sometimes the defense will win such a motion, but it's usually a long shot anyway.
It's a long shot usually because there's factual issues, and there are factual issues in this trial, meaning it's not a legal issue in as much as there are some facts that the government has put forth, namely, they've put forth a statement that they said that she made where she admitted she essentially knew what he was doing. And so whether or not the jury is going to find there's reasonable doubt in this case in terms of if they believe that statement was actually a statement she made, or if she was coerced into giving it, or if it was truthful or not, is a separate issue in terms of judgment of acquittal. They just have to put forth some evidence of it, and they met that threshold.
Well, the other issue that the attorneys addressed alone here in court today was jury instructions. Now, even though the defense still has to present their case, even though the attorneys on both sides have to present closing arguments, eventually the jury is going to receive this list of instructions. I think they said it was 50+ pages. You've been through the jury instruction process. What are you looking for, and particularly in a case like this where the primary charge in this is aiding and abetting the material support or attempted support of a terrorist organization?
Which is a mouthful.
Exactly.
And that's not even 50 pages of it. So, no, what you're looking for is the general instructions, which are going to deal with things in terms of, the judge telling the jury you're not to consider if she doesn't testify. You can't use that against her. It's going to involve things regarding what they should do in deliberations, how the jurors should conduct themselves. It's going to talk about the presumption of innocence that she enjoys from a constitutional perspective and has maintained throughout the trial. And it's going to talk about what reasonable doubt actually means. This is something where a lot of times I think people think of civil cases, and they think, especially because the defense is about to put the case on for themselves starting next week, people think a lot of times, well, whichever side is more believable is going to be the one that's going to win. And that's not how it works in a criminal case. How it works is the government has the burden, the prosecutors, of proving the case as to each element beyond a reasonable doubt. And that doesn't mean that the defense doesn't put forth evidence for the jury to weigh and consider in terms of how that affects whether or not they think the government's met their burden of proof. But in the end, it is the government's responsibility. So you can expect things like that to be discussed, as well as the more particulars about these crimes, which are very intricate and very detailed.
Because once the jury goes back into the deliberation room, they get very little assistance. I know sometimes they will try to ask a question,
yes,
and a lot of times the judge can't answer them. And I know that often the judge will refer them back to this legal document as to how they are supposed to dictate those deliberations.
Absolutely. And usually they're given a copy of the jury instructions so they can take them back with them. So it's It's not like they have to sit there and memorize 50 pages worth of information that's being read to them when they're charged or given the jury instructions prior to deliberation. But a lot of times too, they'll ask to review testimony. You know, they'll want to have a read back is what it's called, where somebody, a court reporter, or if they can produce a paper transcript, if the judge allows it, can allow the jurors to hear again the testimony that was given during the trial. Or they'll want to consider evidence, which obviously they'll have the means of obtaining and reviewing during their deliberations as well.
Well, we're talking jury deliberations, but there's still a big part of this case, which is the defense's presentation. They're not required to give one. Noor Salman doesn't have to say a word. She doesn't have to present any evidence. It's up to the government to prove that she's guilty beyond a reasonable doubt. But nonetheless, what do you expect the defense? I know one issue that they have brought up is that this very sticky confession that she made, and the defense's claim that the FBI coerced and put these words into her mouth.
Well, and again, we've talked about it time and time again, and I always come back to it because it wasn't recorded, you know. I mean, and that is an issue for reasonable doubt. One of the ways that a jury can find reasonable doubt is a lack of evidence, and certainly that evidence is lacking in this case. It doesn't mean that the government, again, hasn't put forth some evidence in terms of FBI agent testimony, and if the jurors believe that she wasn't coerced, and that's what she actually said pursuant to what the FBI agents testified, then they may find her guilty. But I would fully expect the defense to make a big issue of the fact that this wasn't recorded. They've already made an issue of it, but even more so in the context of who she was as a person. You know, she's a more simple person. She's a lower level IQ. She's on the lower end of average or lower level intellectual functioning. She's financially dependent on this man. She wasn't working outside the home. She's very sheltered. She's very naive. And what that would mean in terms of the effect of being interrogated for 10 hours by law enforcement agents when you're not a lawyer and you don't have any legal training and you're in her shoes, like that's more likely to influence someone to give statements that maybe aren't true just because they want to get out of the room, you know, sometimes, or because they just want it to stop, or they think if they say what they're supposed to say, they're being good and they're helping.
Now, and you mentioned right there that the defense wants to present her as this naive, simple person who didn't realize what her husband Omar Mateen was planning, and that he was showering her with all these expensive gifts, taking her on a shopping spree way outside their means, and yet supposedly didn't question this extravagant spending. Obviously, they're going to probably call someone who they've already thrown out that she had a low IQ, 84.
Sure.
So I'm sure they're going to put in some witnesses who can talk about her mental abilities. But I imagine some of this too boils down to her character and getting character witnesses. Is that something the defense can present? Is a family member saying she was such a sweet girl, or is that something that's not quite allowed at this stage?
Well, it can't really boil down to just saying, you know, she's a nice person, she's a sweet girl, I really like her, she's a good person, and she would never do this. It's more an issue in terms of if the government's going to rely, which they have, on this supposed statement, you know, they're allowed to make it their defense that she was coerced, or that she didn't understand, or she didn't even say the things that they said. She said she was misconstrued, she was misunderstood, or the bigger issue here being, you know, character evidence about her will go to, as you've said, whether or not she would have even really felt like she had a choice but to say what she thought they wanted to say, or if she would just say things that weren't true because she didn't understand the questions, you know, things of that nature. So it will go to how she lives and what her life is like. I would expect that, but it won't just be, you know, she's a nice person and she could never do this.
Now, we do know one witness they plan to call is an expert in false confessions. Now, I would imagine the average person would just think common sense. I am never going to admit guilt to something I wasn't guilty of. I would never, that's crazy that I would ever fess up to something I didn't do, but
it's a reality.
You're a lawyer. How often do you see that?
It happens. I mean, I'm not saying that it happens in every single case, you know, it doesn't, but it certainly happens a lot. And in Florida, we have a very high rate of wrongful convictions where people are later exonerated through DNA evidence, especially in older cases where there wasn't DNA testing and things of that nature at that time. And in a lot of those cases, a very statistically significant amount of those cases, like 35%, people gave false confessions. So we later found out not only were they wrongfully convicted and they couldn't have done it because DNA exonerated them, but they also confessed to doing it when there's no way they could have done it. And so in this case, you should expect that the way that she's lived, the way that her intellectual functioning works, her inability to be perceived in the same way as someone of higher or even higher average intellectual functioning is going to play a big role in deciding for the jury, after hearing from these experts, in terms of whether or not her confession was false, which we already know part of it was false. We do know that. That's not really disputed at this point.
And what you're referring to, for those who haven't followed closely, was the fact that Noor Salman told the FBI that my husband and I, Omar Mateen, a few days before the Pulse nightclub attack, drove around Pulse nightclub. But yesterday, one of the last government witnesses testified that looking at their cell phone pings, Salman and Mateen's cell phones were never near the Pulse nightclub until Mateen went there the night of June 12, 2016, and that they were certainly not there the night Noor Salman said they cased the joint. So
she was never there. Right.
Never there, but yet she told the FBI, I was there.
Right.
That's a problem.
It's a problem, and I think that certainly a jury could question a lot of other things about this statement that she supposedly gave FBI agents that we've heard through their testimony, because there's already something they know is empirically not true. So then it lends a question, and that's reasonable doubt, in my mind at least. What else is not true? Can we really trust any of this?
Attorney Whitney Bone, we really appreciate your thoughts on all this. We will be watching intently as the defense begins their presentation Monday morning, and we will have all of the information here on News 6 and clickorlando.com. We're going to send it back to you, Julie.
All right, thank you. Mike DeForest live at the federal courthouse. Get complete coverage, including our team's minute-by-minute tweets from inside the courthouse. Go to clickorlando.com/Noor Salman trial. Join us Monday morning for another discussion. Our coverage begins at 8:30 right here on clickorlando.com. Thank you for joining us. I'm Julie Broughton.